We're going to turn our attention to how our state and federal non-discrimination commissions work. Kai and Connie, can you talk about what each commission is meant to do, when we might engage with that commission, and what the process looks like?
Okay, so start with the federal. Number one, sort of to underscore what Connie said, someone needs to know to come, right? And one of the things I would say, besides talking to 3 people, post this on your Facebook, or take one of the pictures and put it on your Instagram, and then link to the video, okay? Because I did intake myself, so I'll be able to tell you a bit about how intake works. So as a commissioner, I went to some offices and did intake, which totally sort of blew the mind of the staff. Because I'd never had a commissioner come down and do this. But with at least 2 of the people whom I took in their complaints, they had heard about the EEOC through Facebook, through their friend posting something on Facebook. Otherwise, they also knew it from other friends in the workplace. Every employer covered by the Title VII has to have a poster up that says, this is who you call, if you experience discrimination. Some employees find it from that, but friend network is huge. Okay, so you basically, so I'll tell you how it went up until a few years ago, because I'm very proud of this change that I helped lead. And of course, in anything, leadership is only if there's a team that's also working. It's never one person in policy change or systemic change. You could go to EEOC.gov and then get the either 800 number you could call or the list of the offices, so you could show up at those offices and get an interview. About 3 years ago, EEOC finally launched an electronic portal, which is how people do stuff, is be able to do stuff on the web, And again, you can't actually file the charge, but you can go through a whole bunch of questions that will let you know whether EEOC even has jurisdiction, and then schedule an interview with an investigator. So the first step is talking to an intake person at the EEOC. And now you can also do it sort of through video, as well as showing up. Investigator will hear the facts, and then help the person draft a charge that basically says, I believe here are the facts, and I believe I was therefore discriminated against. That charge is filed, has to by statute be filed with the employer within 10 days of the person signing the charge. And so one of the things investigators always tell the person is, we have to tell the employer, and if you are retaliated against in any way, come back and let us know. Because then we will amend the charge to also include a retaliation claim, right? It goes to the employer. One of the things EEOC did, almost 20 years ago now, is before launching an investigation, offers the person who complains, they're called the charging party, offers the charging party the option of having this mediated. So an EEOC mediator who will bring in both the charging party and the employer to see if the issue can be resolved, and have the harassment stop or get the job back, or, and then the employer has to agree to mediate as well. Many charging parties and employers mediate, very high successful rate of mediation. If mediation fails, or if the employer, usually the charging party wants mediation, but if the employer says no, then the investigator investigates the charge. Key thing that I will say is there's a real time lag at the EEOC because it's overwhelmed and under-resourced. So what happens is EEOC has 180 days in which to investigate. If the person has a lawyer, often the lawyer asks for it to be popped out of the EEOC. Certainly at the end of the 6 months, but sometimes the EEOC can issue what's called this right to sue letter before the 6 months. They just attest to the fact that they won't get this finished within 6 months. The statute that Congress passed in 1964 did not allow people to go to court directly and bring a lawsuit right after they knew they'd been discriminated against. They had to go to the EEOC first. And that was done part of the compromise, protect businesses, that you would go to this administrative agency first that would try to negotiate and resolve it before these southern businesses got pulled into court, on race discrimination. So, and that can actually be a totally good thing, right, because it helps people without lawyers, but only if the agency is well-resourced and isn't just a blockage before you go to court. And sometimes it is. And certainly for people without lawyers, and they don't understand that they can maybe ask for that right to sue letter, early on. But if you're going through the process, again, often the investigator will decide there's just not enough information here to say reasonable cause that there's discrimination, and then they give the person the right to sue letter, which then allows the person to go to court. Again, that assumes the person finds a lawyer or just does it what's called pro se by themselves in court. If there is probable cause, then again, under the statute, EEOC must reach out to the employer and offer a chance to negotiate, and that's called conciliation. So there, EEOC is helping the person in conciliation. Many conciliations are successful, which is great. So, and everything in conciliation is confidential in terms of the EEOC cannot say anything. The charging party can talk about something they have filed. An employer, if it wants to, can say we've had a charge filed against us, but the EEOC can never say anything about a charge that is in conciliation. If conciliation fails and the EEOC feels this is a really important case to bring, EEOC has the right to bring a lawsuit against the employer, and then it's EEOC versus the employer. So it's the force of the government. EEOC brings maybe 300 cases a year out of the thousands of charges, again, because of the lack of resources. And also if the person has a private lawyer, often the EEOC will have the person, let the lawyer bring the case. But in important cases, EEOC will bring that lawsuit. So an example of one of the cases in front of the court right now, when the EEOC ruled that gender identity, sexual orientation was covered, we have thousands, we covered like $10 million in damages for people over the course of that. And that was up until 2 years ago. I haven't even checked the stats since then. But, just in this conciliation phase. But EEOC also brought some lawsuits, both on sexual orientation and gender identity. Most of those got settled, right? But the one that was brought against Harris Funeral Homes that had fired Amy Stevens when she said that she was going to be living finally in the gender as a woman that she's always been, EEOC filed that case. So it was EEOC versus Harris Funeral. And whenever EEOC files a case, if the charging party has a lawyer, they're allowed to intervene as of right, just at that trial court level. And sometimes they do, sometimes they don't. Amy Stevens did not intervene, right? So it was just EEOC versus Harris Funerals at the trial court. Basically lost at the trial court, EEOC lost at the trial court, was then appealing to the Sixth Circuit. And at that point, about some months after the appeal, the administration changed. So you had the Trump administration. You had DOJ, Attorney General withdrawing its position that gender identity discrimination was a form of sex discrimination. So at that point, ACLU intervened on behalf of Amy Stevens as her lawyer in the Sixth Circuit. And what's interesting is there's not as of right to intervene at the appellate court. So the Sixth Circuit had to say, yes, ACLU should be allowed to intervene. And ACLU's statement was, we don't know whether the EEOC is going to continue to support Amy Stevens. That's why we need to be in here. And the Sixth Circuit gave the ACLU the right to intervene. EEOC continued to support Amy Stevens through the Sixth Circuit, even with the new administration, and won in the Sixth Circuit. But it's very good that the ACLU had intervened, because the Harris Funeral, represented by Alliance Defense Fund, ADF, appealed to the Supreme Court for review. The Supreme Court accepted review, and under the statute, the Department of Justice, the Solicitor General, represents the EEOC before the Supreme Court. So now it was Department of Justice defending EEOC's position, except that Department of Justice had changed its position. So in the Supreme Court, Department of Justice was arguing against the position that gender identity is covered under sex discrimination. David Cole from, ACLU, Pam Carlin arguing on behalf of, there was David Cole arguing in Harris Funeral on behalf of ABC.